Hey, everybody, looks like we're live. So still got a few minutes to go. I'm going to go get a bottle of water and I'll be back. So in the meantime, if you have any questions, feel free to type them in and I'll be back in a minute. Yeah, and I just sent the link to my family, so that's 6. Hey, if you can hear me, give me a thumbs up or some kind of message where I'll know that you can hear me. Speaking into my blue ball snow cone or whatever it's called. Not blue ball, blue. All right. Okay. Just doing a little test here on the audio. Looks like we're in pretty good shape there. Give it a couple more minutes. Let's see if we have anything worth All right, good. Looks like everything's, all the technology, the Wi-Fi is working great. Got my phone here so where I can read off some of the, or all of the questions that people asked me by email. I've also on the YouTube community tab, we had a few people ask some questions there. I'll get to all of those. Of course, you can, I guess, ask in the live chat. I'll be checking on that. All right. I got 11 o'clock straight up. So let's get started. And all right, so let me just kind of go over what we're doing here. Wow, is all I can say. It's been complete craziness out there, you know, as well as I do. I've been, sitting at home watching the news. I'm actually streaming this YouTube live from my office, and because just we had a couple of people who wanted to get some some stuff finished up and get some estate planning stuff signed and in place, It was scheduled to take place today, and it was scheduled, weeks ago. So we're going to finish that up. Then we're going to be, heading home and complying with our Louisiana governor's stay-at-home order, really until April 13th, unless we get notice that changes. So from an office standpoint, we're, there's three of us, and we'll be working remotely and checking the voicemail messages, and our business is kind of conducive to being able to work virtually. So, but it's going to be very different. So we'll see what the future holds. I know that some people are worried. As I hear in our state, we're seeing something like that last report, 800 something plus coronavirus cases, most of them in the New Orleans area. I think there's been 20 deaths in our state, and then we're seeing New York City get hit really hard, much less Italy and all those other countries that are getting hit. So it's really a scary time from an estate planning side. I mean, even I know the thought's been going through everybody's mind. What if it were to happen to me? What if I got sick? Or even worse, what if this thing were to get me and I were to pass away? Is there anything I should be doing just here at the last minute to prepare myself for that? So we'll be talking a little bit about that, answering questions in general. I really have no agenda for this YouTube live, and so I just like I put out in the communication, just let's talk. So, but I do think while we're here, I'm gonna give you some basics and answer a bunch of questions that have already been asked. I think it should be educational for everybody. And for most of you, heck, what else are you going to be doing sitting at home? Except maybe watching The Price is Right. All right. So let's first go over, I want to, while we have everybody, I want to go over where you can get more information. Some of you are aware, and some of you have probably watched one or more of them, but I've been putting out a lot of effort in the last, really about the last 3 or 4 years, but really in the last 3 or 4 months, been hitting it hard, making all of these YouTube videos. You're watching this live stream on a YouTube platform. I've made about right at, I think, 390 YouTube videos. Most of them last anywhere between 5 minutes and 15 minutes long, and I've made them on a multitude of topics. So if, after this, whatever we call this thing, this YouTube Live, you want to go find out more, or maybe all your questions didn't get answered, go check out the YouTube Live. It's under a channel called Rabelais Estate Planning, LLC. If you put in my name, Paul Rabelais, or just type in whatever your question is in the search bar under YouTube, my videos will likely pop up. I don't think any other estate planning attorney has put out more or has been watched more on YouTube other than me. So, questions related to wills and trusts and powers of attorney and probate and executors and nursing homes and Medicaid and lawsuits and who should I do this? Who should I leave it to? How do I leave it to these people? All of those things that I see on a day-to-day basis, I've made a video on all of the common stuff. And so you feel free to go check that out. It's free. And in fact, a few people in the comments, if you look through the comments to some of those videos, you'll see where several people have said that they've binge watched my videos, and I laugh every time I read that. So, but no, it's a resource there for you to use. By all means, use it. And then, quite frankly, if you want to, subscribe to the channel, that would be great. Give various videos the thumbs up. Constructive comments in the comments section. Those are awesome. Everybody benefits from that. So use that as a resource. Another resource to get more information. I have written a book. It's called Estate Planning in Louisiana. It's on Amazon. It costs $20. It's starting to get a little outdated, although not much has changed in I guess it was maybe 2016 was the last edition I put out. It was the 4th edition. And I know that our estate tax laws have changed, significantly since then. Other than that, all of the kind of basic stuff really hasn't changed much. So it's getting a little outdated, probably due for a 5th edition coming here in 2020 or 2021. But I still say, if you want education, go to the YouTube videos. They're free. All right. Next thing I want to go over is, heck, I'm gonna just jump on some questions, because I wanted to do. I was going to spend a few minutes talking about, if you got nothing and you're worried, all the healthcare stuff, the living will, the healthcare power of attorney, all that, some will or trust, in the short term can get you through some immediate needs. I'm going to come back to that in a minute and really focus on some of the questions. All right. So let me just hit these right here, and some of these questions you're seeing because they're in the live chat. So Bob wrote, Medicaid recovery, is that at risk upon death or still exempt? So before I answer any questions, there's 2 things that make me a little bit queasy. One is that estate planning rules can vary from, they do vary from state to state. So I work in Louisiana, help our Louisiana clients. I've helped, I don't know, several thousand, but laws vary from state to state. And so I'm just giving you my disclaimer. Take what I'm about to tell you with a grain of salt. If you're if you're watching from a different state, it may be different. I'm going to try to point out your state may be different, but here's what it is in my state. You need to check with someone in your state. So it kind of concerns me when I'm answering questions that where the answers can vary based on where you live. The other thing I'm a little worried about is, when I've already had some questions from specific, clients that we've served, and they ask a question maybe about their particular situation and their documents without me doing any research. And kind of the best I can do there is just answer questions in general without doing all the research, going back and reviewing my notes, looking at all the documents that we prepared. So I'm going to do my best, but I want you guys to realize that I'm just kind of shooting from the hip here, but I'm going to do the best I can. All right. So question from Bob, 401k Medicaid recovery, is that at risk upon death or still exempt? All right, so this is one of those state issues. Here in Louisiana, a 401k or an IRA, from a standpoint of, is it a countable resource? And I know you asked about Medicaid recovery. I'm going to get to that in a minute. But here in my state, IRAs, 401ks are a countable resource. So if a single person has a 401k or an IRA and it's valued at $100,000 and they go into a nursing home and the countable resource limit is $2,000, they won't be eligible for Medicaid until they spend that IRA, that 401k down. Of course, they'll have to take it out, pay the taxes, maybe even pay the penalties if they're young, and spend that money until it gets down to $2,000 before they even qualify for Medicaid. In Bob's case, the question really and let me go back on the countable resource side. I know that some other states have provisions in their Medicaid regulations that say if the IRA or 401k is in pay status, meaning that Medicaid applicant is getting required distributions, then I think it's not a countable resource. If you're in another state and you want to chime in, feel free. And then there's the question about estate recovery. For those of you who the state recovery is, it might be common, for example, when you have a married couple, only one of the spouses goes into the nursing home. That couple can have about $130,000 of countable resources or less, and the one who's in the nursing home would qualify for Medicaid. The rationale there being the one who's staying at home needs something to live off of, so they allow that couple to have about $130,000. And then let's say the one who's in the nursing home qualifies for Medicaid. Medicaid pays the nursing home expense. And then after both spouses die, Medicaid has its estate recovery rights, which allows Medicaid to take assets from the estate to pay Medicaid back for what Medicaid spent on the nursing home, residents' nursing home care. Now, in our state of Louisiana, Medicaid only has rights against the probate estate or against the succession, as we call it in Louisiana. And that 401k unless it's payable to the estate, the 401k is likely payable to individuals who are designated beneficiaries. So in our state, in Louisiana, under our rules, the state couldn't go get someone's IRA or 401k after they die that had designated beneficiaries, because that asset was not a probate or succession asset, which our state's Medicaid estate and recovery rights say that they can only pursue those succession assets. All right, so that was kind of high in there, and I hope you're staying with me, and keep staying with me, and keep bringing those questions on. I've got questions on the live chat, and I've got questions on the phone I'm going to get to here in a second. All right, Wyoming is in the house. All right, great. I've helped some friends get a trust set up using a lot of your thoughts. Thanks so much. Wow, very good, Ron. Thank you so much from Wyoming. I never even dreamed someone from Wyoming would watch my stuff. So when you say you've helped some friends, I guess you're just kind of a layperson helping some others, but you're smarter than them now that you've been watching my videos, I guess. So thank you, Ron, for tuning in. All right, I'm going to get to my email questions, and then I'm going to get to my YouTube community tab questions. Okay, going back to, there's 3 or 4 questions that I got by email once I put this out. All right, here's one. So it says, last week your video concerned who is responsible for repairs when a usufructuary occupies a house. Again, a usufruct is a Louisiana term only. If you don't live in Louisiana, you're going to say, what are you talking about? Even if you do live in Louisiana, you might say, what are you talking about? By the way, I have a video that's titled, What is a Usufruct? You can look that up on YouTube. I did not see anything regarding who is responsible for insuring the house and the contents, the naked owners, or the usufructuary. Our trust contains a usufruct until death, but there is no mention of who is responsible for what. Please address the insurance issue in your live broadcast tomorrow. Okay, so there's a lot going on there. So I guess I'm going to start with the fact that it is not typical for people to have, for example, a trust, and then say when one dies, that surviving spouse, for example, has the usufruct. They very well may have accomplished the same thing by using trust terms, like the surviving spouse is the income beneficiary for life, something like that. So that's typically what we see when we use a trust. We don't use the word usufruct, we use other words. And generally the result is maybe a spouse dies, grants that surviving spouse through the trust, that ability to use the deceased spouse's share of the trust assets, with the ability to even make distributions to the surviving spouse from the deceased spouse's share of the trust for the surviving spouse's health, education, maintenance, and support. To answer the question, if there's a house in a trust and rights are given to the surviving spouse or someone to continue living in that house for the rest of that person's lifetime, it's going to be typically the deceased spouse's assets that are going to be used to maintain, insure that house. It certainly wouldn't be the responsibility of what I'll call the principal beneficiaries, who's going to get that house after both spouses pass away. So in a typical scenario, it's the surviving spouse who has the right to live in the house, and the surviving spouse can use the assets of the deceased spouse to maintain, insure that house. Now, we do have a question. In there it talks about contents. Contents are different from house. So maybe when the first spouse dies, it could be possible that that spouse left ownership of the contents to the surviving spouse. And in that case, then the surviving spouse is the 100% owner of all of those contents. And so, it's going to be, surviving spouse or whoever the owner is of those contents can do whatever they want. A lot of mouthful there. The deal is, when you have a trust, you're probably not leaving usufruct. Usufruct is more commonly used in a will, where a spouse leaves usufruct of their real estate to their surviving spouse. And then when the first spouse dies, we've got to go through the probate to establish the surviving spouse's usufruct. Oftentimes, to eliminate the probate, put the assets in a trust, use words other than usufruct, which give that surviving spouse the right, and in certain cases, the obligation to live in, insure, maintain that home. All right, so that was another mouthful. All right, let me go back to chat here. Okay, so D wrote, what about the new IRA and 401k rules for children having to withdraw all the money in 10 years? So thanks, D, for that. That's all about the Secure Act, which was passed in late December and took effect for IRA owners who died on January 1st, 2020, moving forward. So I'll touch on that. Under the old rules, first of all, the age where required distributions must begin has been pushed back from 70 and a half to 72. And the rules that apply when you leave your IRA to your spouse haven't changed. That money goes into a, husband dies with a $500,000 IRA, names his wife as the primary beneficiary. He dies, it goes into an IRA that she owns, and those rules haven't changed. But when the wife dies and she has her 3 children, for example, as the beneficiaries to receive the IRA when she dies, those rules have changed significantly. Under the old rules, if the wife had died before January 1st of this year, the children could take required distributions over their remaining life expectancy. So if there were 40 when mom died, the kids starting the next year could take distributions probably, for their remaining life expectancy, which could be for another 40 or 50 years. But under the new Secure Act, the children must take all of those taxable distributions within 10 years after mom dies. So it in some cases speeds up how quickly the IRA must be distributed, with taxable income to the children after that surviving spouse dies. Often it isn't a case because we joke around the office. The biggest question the kids seem to have is do we take the money out before they bury mom or after they bury mom? So, with inherited money, I know this is not the case in all cases, but inherited money just, it isn't earned money, and often it isn't appreciated. Yes, the ones who have a lot of careful planning and forethought, those kids often do take those distributions over their life expectancy, but now they'll be forced to take them out over 10 years. There is a bit of a delay because a child could wait until the 10th year to take any distributions and take it all out 10 years later. So there is even more opportunity to defer the start of the distributions, but it's all got to come out in 10 years. Okay, so thanks for that question, D. Let me go back to the questions here. Another good question. We get this from time to time. What are the implications if a couple who created a trust together divorce? All right, so again, there's all kinds of different trusts. There's all kinds of different state rules. But let's talk about the typical scenario. John and Jane, they're happily married. They set up a trust. They put all their assets in their trust. And their trust says, when one of them dies, things are for the surviving spouse. After they both pass away, things are for the kids. The reason they did a trust is because they didn't want the surviving spouse or the kids to have to go through, the court process of getting an estate settled when assets are in your name when you die, assets in the trust, avoid all that. Okay, but after they set it up, they get divorced. So most trusts, and you'll have to look at the language, most trusts say that that at least here in Louisiana, we live in a community property state. So couples own community property, married spouses may each own separate property. And typically when assets are transferred into a trust like that, they retain their community or separate property status. Although there is the possibility that a spouse may have separate property. Let's say they inherited $100,000 in a bank account, and the minute they get it, it's their separate property. But if they commingle those funds with other funds that they have with their spouse, it's likely to become community property. And so even in a trust, if separate property gets commingled with community property, it's likely to be commingled. So when that couple gets divorced, they likely, split the community property. And then the spouse, if a spouse had separate property in the trust, that spouse would that property would be removed from the trust and owned by the spouse who put it in the trust as their separate property. So that's a good question. Thank you for that question. Moving on here. All right. Okay, so in a minute, I'm going to answer a couple more questions. Then I'm going to go back to kind of your, oh my gosh, I'm stuck for 3 weeks. I got no estate legal affairs in order. What do I do? Do I do anything? Do I do nothing? Or is there something I can do quickly? I'm going to get to all that in a minute. All right, but going back to a couple of more questions. Got a 10-part question here. Okay, but most of them are going to be fairly quickly answered, but they're all good questions. Okay, and so says Mr. Rabelais, thank you for doing this. I, as well as many others, your expert guidance on estate planning. I am still not certain that I have a good understanding of fully funding your revocable living trust. We get a lot of questions about what does trust funding mean, or what does it mean to fund a trust? We get that a lot. I have the following situations and wonder if the items that have beneficiaries defined are in proper order. Looks like it's somebody from Louisiana because they talk about their primary residence and put in quotes Louisiana. But let me go through the list here, and a bunch of these questions can be answered with one answer. So the first 4 types of assets that they asked about were IRAs. They were IRAs that had different types of underlying assets in the IRA account. But one was IRA indexed annuities have beneficiaries defined. IRA brokerage accounts have beneficiaries defined. IRA REITs have beneficiaries defined. IRA managed investment fund accounts have beneficiaries defined. Okay, so every IRA, the IRA owner, when they establish the IRA account, they in 99.9% of the cases, unless there's just a screw up, they designate beneficiaries of that IRA. Whether the underlying assets in the IRA are annuities, stocks, managed investments, REITs, it doesn't matter. There's going to be a beneficiary named. And as long as there's a beneficiary named, all that stuff, those IRAs don't need to go into the trust, don't need to be retitled into the name of the trust. Funding a trust means titling assets that are in your name that need to go into the trust is funding the trust. Another word for that is retitling the trust, or retitling the assets into the name of the trust. But an IRA really can't be owned by a trust. An IRA has to be owned by an individual. Yes, a trust can be named as a beneficiary of an IRA, but an IRA owner can't transfer their ownership interest to a trust. So it is not typical to fund a trust with an IRA. So that answers the first 4. The next talks about this one here. Everything seems to get tricky, but this is where it gets tricky. Non-IRA managed investment fund account have beneficiaries defined. Okay, so many people own their retirement savings in their IRAs, and many retirees at the brokerage institution, they have their IRA. Perhaps it's a traditional or a Roth or both, and then they also have call it a non-IRA, call it an individual brokerage, joint brokerage account. That's a separate account that's not part of their IRAs, and their IRAs have beneficiaries. So this separate non-IRA account, here's where it gets tricky. In many other states outside of Louisiana, they allow you to make certain designations on those non-IRA accounts. TOD, transfer on death. So John has a non-IRA account in his name, transfer on death to his 2 children, 50% each. Here in Louisiana, though, Louisiana law doesn't recognize those TOD, transfer on death designations, joint tenants with rights of survivorship designations that virtually every other state honors. So here's where it gets tricky. Some of the national brokerage firms will permit its Louisiana customers to title their non-IRA brokerage accounts and include that TOD designation on there. However, when you die, if your trust beneficiaries, because you have a trust and you're asking a question about funding your trust, if those trust beneficiaries are different than the people that you designate as beneficiaries on that transfer on death form, there could be a potential problem. So we do think that you ought to retitle those non-IRA, as you call it, managed investment fund account, fund that in your trust or retitle it so that the title of that account is titled in the name of your trust, which that title might be something like John Smith as trustee of the John Smith Trust. Okay, moving on to number 6, life insurance. Yep, have beneficiaries defined. That doesn't need to go into your trust under normal circumstances. You've got a bank checking operating account titled simply in your name. Again, it gets tricky with bank accounts. A lot of people who have their main checking account and they do their estate planning and they set up a trust to avoid probate. They don't like the concept of having to get a new checking account titled in the name of their trust because they've got all their bank draft stuff, direct deposit, bank draft stuff going into and out of their personal checking account. But if that personal checking account is in your name only, it'll be frozen when you die, and your survivors will go through lawyers like me and have to go through the courts to get access to it. So some people, in fact, a lot of people have done this before they even come into the office to talk to me about it. A lot of people, even before they come in, they go talk, they bring their child, their adult child, to the bank, and they add their child as a signer on their bank account. Still your money, still your social security number on the account, but that additional signer has access to those funds. When you pass away, the account's not going to be frozen. So we see people, and you're asking a question here about funding your trust. We see many people with trusts still keep their personal checking account in their name, but make sure through some vehicle, child as a signer, or I know certain banks in Louisiana permit this POD designation, payable on death. Another tricky scenario, but a lot of our clients have set it up that way. That's a way for people to gain access to your funds after you pass away without having to go through all the court and attorney involvement. Okay, just a couple more here, then we're moving on. Bank checking emergency fund account titled in the name of my revocable living trust. There you go. So that's taken care of. That account won't be frozen when you die. Whoever is the successor trustee of your revocable living trust can present that trust instrument to your bank when you pass away, and the bank will give access to that account to your successor trustee without needing all the courts and lawyers to get involved. Oh, by the way, having to get anything done through the court system right now, boy, that's a tough one. I don't know the details. What I hear is that courthouses are open for emergency filings only. Maybe it varies from parish to parish, but some things are going to sit for a while. Number 9, my primary residence, Louisiana, is titled in the name of my revocable living trust. Good. So when you pass away, if your survivors need to sell your home, for example, your successor trustee of your trust could sell your house the day or the week after you pass away without, all of the typical delays when it's in your name and your family's got to go through the court process, which is shut down right now, in order to get that house retitled. Texas farm acreage in the process of being surveyed and deeded will be titled in the name of my revocable living trust. Okay, so there you have it. Hope that helps. Initials EZ. How about that? Easy. Initials EZ. EZ just made it easy for his heirs. Don't all of you laugh at the same time to that joke. All right. Moving on to other questions. Okay. See what we got here. We're going to go with, I want to say, so here's a question, is there an additional fee if a client wants to come into office and ask advisor questions about enacting estate procedures? Is the designated estate custodian allowed to talk to you also? That's a tough one. I really don't understand what's going on here. My kind of fallback answer is contact the office, Brooke, who fields all of the incoming calls. There are many, many circumstances with existing clients where either Brooke can resolve a question quickly, or Brooke can ask me and get a question resolved quickly. So in that case, that's pretty easy. Then there are other cases when people call the office and there needs to be more involvement. It's really done on a case-by-case basis. The very first words of the question were, is there an additional fee? It really all depends on the circumstances and what someone is requiring. So I would just say, get the process started by resolve things. Sometimes things get resolved without people having to pay for services. Sometimes things are more complex, and so so legal services are necessary, and of course, fees result accordingly. We always let people know in advance what those are before anybody commits to anything. So tough one to ask here. And so, when you say estate custodian, I don't even know what really that means. Or to ask advisor, does that mean lawyer? So a lot of unknowns there. So I just gave you my kind of default answer. Okay. Here's a good one. Do you have any advice about today's stock market crash? This shouldn't change anything with the trust. So that is huge, D. And as I pull this stuff up, Dow Jones Industrial down 664 points, down to 18,500. That is awful. And when it was just in recent months, the Dow Jones Industrial Average was around 30,000. Now it's down to 18,000. That is a tremendous loss of wealth, causing great stress to many people out there, quite frankly, including myself. And so there are many people who, we haven't heard all the stories yet, but I know that there are many people out there, retirees, who retired last week, last month, last year, 5 years ago, and had an expectation that they would have X dollars, and now they have X dollars minus 30 or 40%. And so now they're worried that their money is going to run out. It's awful. Let's all hope, for everybody's sake, that this problem that we're going through with the coronavirus is short-lived, so the economy can get back, businesses can get back, and people's portfolios can start going back in the right direction. But it is awful. All right. Now, how does that affect people's trust? Is a very good question. Your question that shouldn't change anything with the trust. And the answer is it shouldn't. And in the overwhelming majority of cases, it won't, because most people's estate planning documents are general in nature. And the effect of those estate planning documents are just, whatever I own when I die, it goes for my spouse. Whatever I own when I die, it goes to my kids equally. Whatever I own when I die, I leave 5% to each of my grandchildren, and I leave the remaining 80% to my children equally. And those things, that all, works just fine, regardless of the fluctuations in value of what someone owns. Now, where it potentially could affect things, and this is where, you got to be real careful, because the more particular people get in their estate planning program, the more risk that something goes wrong. So the grandfather who's sitting there on his $1 million portfolio, and he has 6 grandchildren, and he says, I want to leave $100,000 to each of my 6 grandchildren, and then I'll leave the rest to my 2 children equally. I've got $1 million. So if I leave $100,000 to each of my 6 grandchildren and I leave the rest to my children will each get $200,000 and my grandchildren will each get $600,000. But when he dies, either because of the stock market crash or he spent money on maybe long-term care or healthcare needs, let's say he dies and he only has $400,000 in his estate. Well, he doesn't even have enough to cover the 6 specific $100,000 bequests. So those will get reduced proportionally. Each of the grandchildren will get $75,000. That'll make up the $400,000, and his children will get nothing. So to the extent you've gotten real specific with that or intend to get real specific, be real careful. I would say in general, if you're going to leave an amount to grandchildren, do you leave them an amount when it's just a kind of a token amount. I leave $5,000. I want to acknowledge this person, so I'm going to leave them $1,000 or $5,000. But that grandfather who wanted to leave $100,000 to his 6 grandchildren each and the rest to his kids, maybe he should have done it all in percentages, where he left the grandchildren a percentage and the children a greater percentage. So that way, it would have worked out better. So, but really with the decline in value of things, it really doesn't affect people's trust programs. Now, the other area where it can affect people is in the estate tax area, but that affects so few. So sometimes people's bequests are tied into the estate tax exclusion amount, which is $11.58 million. And so when that's the case, maybe significant fluctuations in value may affect people's estate planning decisions. Good question, D. All right. Do you serve clients outside of Louisiana? Natalie, thanks for the question. General answer, no. I'm a lawyer. I'm licensed in Louisiana. I give advice to people in Louisiana. So there we go. All right. All right. So we have we have bank stock held in a subchapter, probably meaning subchapter S. The bank is a subchapter S corporation, and the bank doesn't want to rename it as in the trust. What happens when both spouses die? Well, if the bank refuses to retitle your bank stock, really you're asking me if the stock is still in your name when you die, then they'll need to be a probate or a succession if it's in Louisiana to transfer that bank stock, assuming you have a pour-over will, which you probably do if you have a trust, and I'll get to pour-over will in a minute. Assuming you have a pour-over will, which just about everybody who has a living trust also has a pour-over will. That pour-over will says if I own anything in my name when I die, I leave it to my trust. So that way, if you do own the bank stock in your name and you pass away, there'll be a probate necessary to transfer that stock from your name to the trust, and then your successor trustee can disperse all of the trust assets to your beneficiaries. So that's the deal there. All right, let me go back to my email questions. Stock market, hey, gained 100 points since we last checked it, 566 down, 18,607. Never thought we'd see those depths. Just awful. Be happy to hear your comments on the stock market as well. Everybody's worried about it. It's awful. Okay, on the live chat, feel free. Going back to my email questions. I may have gotten them all. So I need to go to my YouTube community tab questions. Okay, let me go here. I'm losing my signal. Is it me or your broadcast? If anybody else is losing the signal, let us know in the live chat. Otherwise, it's probably you, but it could be me. All right, so let me go to the YouTube community tab questions. Okay. This one's a doozy. Let's see. I'm currently going through a situation where the power of attorney health has signed her name on the deed to the house. I was told the power of attorney for health can't transfer property in their own name. Can you discuss this? P.S. When she transferred the property in her own name, my mother was in a rehab facility and dosed up at the time. So I read the question. It's you can read the question if you go to my YouTube channel and the community, you'll read it. So there's a lot going on there. So let me do my best. All right. So if someone, and we're going to get to this in a minute when we talk about, what you should have in place right now, or maybe even what you could get in place while everybody's staying at home. And but anyway, let me get to the question. So it's weird. This one's a lot of issues here. So looks like mom gave a healthcare power of attorney or signed a healthcare power of attorney, let's say to a daughter, which basically the mom signed a healthcare power of attorney that says, in general, if I can't make my medical decisions for myself, I appoint my daughter, whoever, to make them on my behalf. And the person who asked the question is saying, well, the daughter used that healthcare power of attorney to put the daughter's name on the house. So that doesn't make any sense, because a healthcare power of attorney doesn't give anyone the authority to put someone's name on a house. That we may be having the financial or property power of attorney question about that, but certainly not with a healthcare power of attorney. So just that daughter would not have the authority to do it. The second issue that pops in my mind is, if you do give someone power of attorney, their underlying obligation under power of attorney law is they're given the authority to do things on your behalf, but they must do things that are in your best interest. So someone using a power of attorney to take assets out of your name and put them into their name, that's a violation of the obligations that an agent has using a power of attorney. So we got more problems there. Not to mention, if the mother was in a rehab facility, I don't know if that's really relevant to my legal answer here. So that's what we got going on. All right, another question from Gloria. Should I record with my county a certificate of trust for my home? Does that make it easier for my children to sell the property, or is that unnecessary? All right. So again, when you talk about county and when you talk about certificate of trust, you're talking probably from a state outside of Louisiana, but I think, I can speak generally here. So when someone has a trust, that's typically all very private information. But when they transfer their home to their trust, they typically, and many state laws, if not all state laws, require this. They require that you have it written here, certificate of trust. In Louisiana, we often call it an extract of trust. I call it short document needs to be recorded in the land or real estate records where you live, so that if you, or when you die, your successor trustee goes to sell your property, the title examiners can look in the land records and see who has the authority to transact the real estate on behalf of the trust. So if John and Jane Doe have their living trust, their house is in their trust, an extract or certificate of trust would have been recorded in the real estate records, saying that John and Jane are the trustees of the trust, and when John and Jane both die, their son Fred is the successor trustee. John and Jane die, Fred goes to sell the house. The buyer's title examiner goes and checks the land records, sees that Fred is the successor trustee, because that's what it says on the extract or the certificate of trust, making it easier for Fred to sell the house after John and Jane pass away. So that's a good question from Gloria. And again, check with your state rules, but that's the general discussion there. All right. A question from Ron from Wyoming. Hey, Ron. Do nursing homes have a certain number of maximum Medicaid residents they deal with? Tough question. And I don't know if I even know the exact answer. I'm just going to give you my experience answer. All right. So I'm going to start with the basics. So in communities, there are assisted living facilities and there are nursing homes. And then there's a mix, but we'll get to that in a minute. So assisted living facilities, those are all private pay facilities. And if someone lives in an assisted living facility, Medicaid is not paying for it. They're paying, they're paying rent. They're paying for whatever services they get. Those are all private pay facilities. When someone needs that skilled care above and beyond what the assisted living facility provides, then they often go into that skilled care, or commonly referred to, nursing home. And not every nursing home is a Medicaid facility. Most of them are. I know in my community, there's, I think, 2 that are exclusively private pay, and then there's maybe 20 that have residents, some of whom are Medicaid recipients because they qualify based on their assets and income, and others who are private pay residents because they don't qualify for Medicaid based on their assets and their income. So going back to Ron's question, do nursing home has a certain number of maximum Medicaid residents that they deal with? I don't know. That's a good question. I just know that here, when there just always, there seems to be enough facilities to handle all of the people who qualify for Medicaid. So I think about 75% of the nursing home residents in Louisiana are on Medicaid. About 25% are private pay. But I would, up in Wyoming, check with people who know better there. I don't even have the perfect answer for you here in Louisiana. All right, MB says, thanks for the good info. All right, so what I want to do now is I want to go back to that emergency stuff. This is the I'm holed up in my house. I've procrastinated for years on getting any kind of legal affairs in order. Now I'm being told to stay home. There's this coronavirus going around. I don't have it. I don't show any symptoms, but I might get sick. I might get the coronavirus. And even if I don't get the coronavirus, I'm not getting any younger. So I want to make sure I make things easy for my family. What do I need to do? So that's what this discussion is about. I guess I'll go into just the immediate, oh shoot, I got nothing in place and I might get sick. And so is there anything I can do quickly to get things in order, make it easier for my family? And then maybe long-term stuff. We'll talk about that for a minute. Okay. So yes, Nika B. So many people have procrastinated. And so here's the deal. And I suspect there's a group of people out there that are holed up in their house. They're like, I'm not worried about estate planning. I'll get through this and I'll deal with it later. And it's just how they feel, and right, wrong, or indifferent. And then there's other people who were like, oh, I'm meant to do it, but I didn't. It was on my list. And based on life events, I kind of wish I would have. And I'd kind of like to know what I should do now. So I would say the very basics, if you want to get just some basic things in order to get things squared away for your family, let's talk about on the healthcare side first, because there's mainly 2 things that you can do there, and relatively easy, that can make things much, much easier for your family in the future, whether you get the coronavirus or whether you live another 30 years and go from there. So virtually everybody, when they put their legal affairs in order from a healthcare perspective, they do 2 things. They do a healthcare power of attorney and they do a living will. The healthcare power of attorney, sometimes it's called a medical power of attorney. Sometimes it's called a healthcare proxy, HIPAA authorization. And then there's a separate living will or living will declaration. So let me talk about the living will first. So the living will, that's everybody confuses it. So, I know when I ask people, going through the process, hey, if you're, in a surgery or you're sick and you can't make your routine medical decisions, who do you want to make them for you? And they'll say, well, don't want to name my son because he'll pull the plug right away. That's different. So the living will is where you don't appoint someone to make that, take me off of life support machines decision if I'm a vegetable with no chance of recovery. The living will is where you make that decision yourself and you direct that your family and your doctors honor that decision. So it's usually expressed something like, if I'm in a vegetative state, there's no chance of recovery, the machines are serving only to artificially prolong the dying process, I direct that my family, my doctors honor my wishes, that that the life support machines be withheld or withdrawn, but I have enough medication to be comfortable. So that's the living will. And here in Louisiana, it's fairly easy to do. You don't even have to have it notarized. It does need to be witnessed by two people who are not, family members who can't inherit from you. So that one's fairly easy to do. If I was really on my game, I'd give you a site, but you could probably go online, dig around, and find a Louisiana living will form. If that is a concern to you, and get that signed in the presence of two non-family member witnesses, and that piece could be in effect. That one's really easy to do. Then the other healthcare piece is that healthcare power of attorney. That's the scenario where you're not necessarily on life support, and you're not in a vegetative state with no chance of recovery, but you're alive, but you're in a condition where you can't make your own medical decisions, and doctors and healthcare providers need to know who to talk to about your treatment decisions. Maybe you have dementia, maybe you have Alzheimer's, maybe you're in a surgery, maybe you're under medication. That's what the healthcare power of attorney is for. And so that's where and you appoint people who would have the authorization to make those decisions. If you're married, you may appoint your spouse. And you may appoint your spouse first, and may appoint a child or children as the backups. We tend to suggest that people not appoint, 4 people having to work together to make your medical decisions, because sometimes medical decisions need to be made quickly. And so if you want to appoint 4 people to make those decisions, we say that, the 4 can make it, but acting jointly or separately, meaning any of them would be authorized to talk to healthcare providers and allow, treatment to take place. All right. So that one is a little more difficult to implement immediately, because virtually every healthcare power of attorney is written in a way where it needs to be notarized and witnessed by 2 people. So now, I was kind of researching some of this before we started. In theory, a healthcare power of attorney does not need to be notarized to be valid, but to have the right effect, a third party like a hospital is going to have to honor it. And the hospitals are probably so used to seeing the notarized, witnessed, we call it authentic act, documents with all of the health care authorizations in there, including all of the HIPAA authorizations, that while it may be valid, a third party like a hospital may not honor it unless it's done with the notary and witness stuff that is so typical of healthcare powers of attorney. So, but nonetheless, another one that's fairly simple, but you've got to track down a notary. I guess if you were wanting to get it done immediately, I don't know, some of these Walmarts and grocery stores of the world have notaries. I don't know if they have those now. There's in every community, there's mobile notaries who will come to your house when you need to notarize something. I don't know if they're doing that under this environment that we're in with the coronavirus, but those are some things. Those are the couple of healthcare things that you can do fairly quickly. On the financial and kind of the business, the property, the asset side, there's a couple of things that if you're trying to get some things done quickly, here's what you got there. All right, so there's the financial power of attorney, sometimes called the property power of attorney, the general power of attorney, the durable power of attorney. All of that is if you get to a point where you're not able to deal with your accounts and sign your name or sell your vehicle or even sell your home if that were necessary and you were alive, this is where you can designate people to do that for you. Most people, if they're married, they appoint their spouse, maybe appoint an adult child or children as the backups. And so that really is something that every adult needs to have in place. If you don't have that in place, and you need to transact your IRA because assets need to be managed or distributions need to be made, and you don't have that power of attorney in place, then somebody's going to have to sue you in what we call interdiction proceeding. Other states call it a guardianship proceeding. It is a really legal nightmare when the courthouse is open, and you get sued, you get an attorney appointed for you, delays have to run, you have to be examined by doctors, court hearings take place, a judge has to declare you legally incompetent, take your capacity to do things for yourself away from you, judge has to appoint a legal guardian for you. In many, many, many cases, all of that can be eliminated if you had signed this, financial power of attorney authorizing the people that you'd want to be able to do that kind of stuff for you. So that also, I would say, that one does have to be, at least here in Louisiana, what's called an authentic act notarized, and then 2 additional witnesses. Because if our laws say if someone's going to sell a piece of real estate on your behalf using the power of attorney, that real estate transaction is done in the presence of a notary and 2 witnesses. So the power of attorney authorizing someone to do that has to be in that same form. So again, though, with notaries around, and notaries are kind of readily available, mobile notaries, some retail establishments. I don't know if they're available right now today, or especially starting after 5 o'clock with the stay-at-home order that we have in Louisiana, starting at 5 p.m. today. I don't know how that stuff's going to be available, but that's. And then the other is kind of quickly getting something done is that that will or trust scenario. So when people are in an emergency and they want to do something fairly quickly, we typically see those people getting wills done. And they just leave the assets in their name. They realize there's going to be a probate or a succession to get them transferred. But the reason people do wills at the very last moment, a couple of reasons. One is if you don't have a will and you pass away, then your state determines who gets your stuff. And your plan is likely to be somewhat different than what the state says who should get your stuff. Here in Louisiana, particularly for married couples, our state really favors the descendants over the spouse. Most people who are married, they want to give their surviving spouse more rights than what these intestate, unite without a will, without the give more rights to their spouse than the laws that apply when you don't have a will give the surviving spouse. So so it is important for that reason. So you get to control who gets what you've worked for. And then maybe even just as important, in your will, you'll have an executor designation and an alternate executor designation where you'll designate who will be in charge when you pass away of making decisions of how your stuff gets handled and managed from the time that you die until it does get dispersed to the people that are named in your will. That's a really important designation. Having the right person do that can be life-changing versus having the wrong person do that life-changing. I know, I believe it's 26 states. I'm talking about the emergency. You got to do something fast. 26 states permit, Louisiana calls it holographic, other states call it holographic wills, where people can write their own wills in their own handwriting, nothing notarized, nothing witnessed. So that's the piece that's available for someone to do, without having to get any outside help or assistance. The concern over handwritten wills always has been, it hasn't been how do we make it valid, at least here in Louisiana. It just needs to be entirely, dated, written, and signed in your own handwriting. But the question and the knock on handwritten wills has always been the layperson isn't trained to have the language set up to be, just right, so that it doesn't create more problems than not doing anything to begin with. So, I will mention, I'd be anxious to hear some comments on this. I've been working for the last probably 6 months. My plan is, and give me your feedback in the live chat, is just if there's some interest there, or if you'd be interested in seeing something like that. I've been working on building this website for the states that permit people to handwrite their own wills, where it's got all the forms, all the sample provisions. It's got some video instruction. It's got some written instruction. So people will be able to, do their own handwritten will under those circumstances. And really, it's set up for the simple matters. You want to leave everything to your kids equally. You want to leave things in percentages. You want to leave things to your spouse, or even you want to leave things in a trust for your spouse so that your spouse can use it. And then when your spouse dies, it goes back to your kids. Or maybe you want to make a couple of specific bequests. I want to leave my car to this person. I want to leave $10,000 to this person, and I want to leave the rest to my children equally. We can show you how to do that in a handwritten format if you're in one of the 26 states that permits that. I know some of those 26 states include, of course, Louisiana, Texas, California, New Jersey, and then there's others as well. So if you'd love to see some feedback, just because I've been working so darn hard on it, as to whether that would be something that would be of interest to you. Okay, and then moving forward, let's assume that we get beyond all this coronavirus stuff, and you want to do, you kind of want to do it right, take your time, not in a rush like some people are right now. What are some of the considerations there? So probably maybe 3 of the biggest considerations when we do it right, kind of take our time, is some people want to avoid probate. Some people want to avoid losing what their life savings and their home if they go into a nursing home. And some people's emphasis is avoiding taxes. And so let me just touch on those. When we touch on what, some people say, I want to make it easy for my spouse and kids or whoever I leave behind. I don't want them to have to go through any kind of, bureaucracy, red tape, government interference. So a lot of people set up these living trusts, makes the settlement process simpler. So because you'll designate a trustee who will handle your trust assets when you die, and they'll have immediate access to be able to disperse assets to your trust beneficiaries in accordance with the terms of the trust instrument that gets prepared on your behalf. So that's a big one. And I would say don't try to do that like in 5 minutes or less. I did make another YouTube video. In fact, in the last 7 days of my 390 videos, it's been my #1 watched video in the last 7 days. It's titled How to Make a Valid Will in 4 Minutes or Less. And it talks about, it shows me just sitting down and handwriting a will using the right terms for a hypothetical gentleman named Will Writer. So for your viewing enjoyment, feel free to take a look at that. But that handwriting a will doesn't get into the probate avoidance scenario that so many people wish to have. The other scenario that takes a little more time to get implemented is I don't want to lose everything if I get sick and I go into a nursing home. That's a middle class problem. The very, very wealthy, they can afford the care that they need. The very, very poor, they're going to qualify for Medicaid and get the care that they need in a nursing home. The middle class, the people with $200,000, $300,000, they're going to get wiped out if they have any kind of extended nursing home stay because they won't qualify for Medicaid, and they'll have to deplete what they have down to $2,000 or less before they do qualify for Medicaid. So they'll lose everything, and then potentially they lose their home when they die due to Medicaid's estate recovery rights that we talked about earlier in the YouTube live here. So many people, and this takes some careful thought and takes, got to do it right. They'll create, let's call it a family trust. Lots of videos I made on that. So feel free to, search Protect from Nursing Home, Irrevocable Trust, Medicaid Planning, Medicaid Eligibility on my YouTube channel. And you can watch lots of videos there. But many people do transfer assets to a very particular kind of trust, and it removes those assets from being a countable resource that would have to be consumed if you went into a nursing home. There's a 5-year deal there. So, people today, they're not anxious to protect stuff if they go to a nursing home because of the 5-year waiting period. People today are worried about, I need affairs in order, today in case I get sick tomorrow. So this nursing home stuff is probably going to be put on the back burner until we get past all of this disaster that we're in and people can focus more on long-term protection. And then a third issue is the taxes. And some people kind of incorrectly, when I bring up taxes, they'll say, well, not a problem for me. because I don't have anywhere near these estate tax limits, whether it's 3 million or 5 million or 11.58 million, which it is. But nonetheless, even though you don't have a large estate, your estate is likely to have both income tax and capital gains tax consequences. So again, in the interest of time, I'm going to refer you to my videos. Lots of videos, the double step up in basis, not a term you hear much. Income taxes on IRAs versus non-IRA assets, step up in basis. All those are things you ought to make yourself familiar with so that you can structure a plan that works for you and keeps what you have in your family. Okay, let me go back. Let's see here. All right. Thanks for highly recommending Paul's book. Really helped me with getting my thoughts organized. Okay, very good. Okay. All right. So with that being said, hour and 10. Okay, very good. So we're going to shut it down, and I will likely do this one more time during our stay-at-home order. I'll announce it a little bit more and be able to answer more questions. I hope this has been helpful to me. In the meantime, number one goal of all goals, stay healthy. Keep yourself healthy, and keep yourself from getting infected, and keep yourself from infecting others. So even though I don't like the fact that I'm going to be staying at home for 3 weeks and probably not getting out much at all, I'm going to make the best of it, just like everybody else should do. Spend time with family, take advantage of my free time to be able to work on things that I've been meaning to work on but haven't. And but number one, stay healthy. Number two, I guess just a little bit of the salesman in me wants to say that if you do live in Louisiana and you want to have a talk, me and my 2 employees are going to keep going. We're going to do the work that we can do. We're going to twiddle our thumbs a little bit because nobody's coming in, although our business is conducive to working virtually. If you want to talk about some stuff, you can go to our website, rabelaestateplanning.com, and there's a button you can click that will take you to my calendar for you to schedule just an introductory call that may last 15 minutes or less, where you can arrange a time for me to call you. I'll call you from my home. You'll likely be at home, and just start a discussion about whatever it is that bothers you from an estate planning perspective. So just know that is out there if you need it. All right, y'all take care. We'll see you next time.